traditional wedding and a white wedding. At what stage do we say that such a person is married?
You're asking me a very uncomfortable question because it wants me to either respond technically as a lawyer or to respond within context of being a black person.
You can wear as many hats as you like.
No, I'll start with the second one.
Yes.
There is this misconception by a lot of people that a customary marriage is lesser than a civil marriage or a white wedding, as it were, because traditionally they go and do a white dress and suits and there's an altar and there's, and they would see that as the actual wedding.
Yes.
And they would see everything else as preparation.
Yes.
Now look at what we had adopted. And if we had decided to waive the requirement of the handover and so forth, are we then not married? It becomes an argument of convenience for me to say to my wife, no, you are not my wife. They didn't do a handover. But at the time when we were getting married, we chose to forgo that aspect because it was an impractical and it was an unnecessary thing as far as we were concerned. The rest is ceremonial things, sort of like to perfect it, but they're not mission critical.
So as long as there's a meeting of the minds between the two families,
yes,
then we're done. It's a marriage.
Then we're done. You're married.
What's a marriage in community of property?
Shamina, shamina. Joint estate. If I go and borrow 50 rand from somewhere, you have borrowed 50 rand as my spouse. If I get a windfall and I win a competition and 100,000 there, you have won 100,000. There is no me, there is no you, there is us.
One more week, one more episode of the Professionals Network podcast with myself, Theo Mapheto. This is a platform where we like what we say and we say what we like. We bring you professionals from all walks of life. Today, I have an attorney friend of mine. His name is Thato Mahapa. He's also a presenter of a TV program, Ngishate Wrong, on Mzansi 163. Welcome, how are you?
I could complain, but no one is going to pay me for that.
You are an attorney.
Yes, sir.
What does an attorney do?
Everything that anyone else doesn't want to do. I have to absorb people's problems and pull a rabbit out of a hat and still satisfy all sides on the table. So I think I'm a magician. That's what attorneys are. They're magicians because we have to find solutions where there are none.
Are you suggesting that you're making tons of money for that?
Hey, I wish, eh? I wish. They say lead with passion and the money will follow.
Yeah.
So I'm just hoping the money doesn't lose the trail where the passion is going.
So it's still coming?
Hopefully.
Now, but you're also a TV presenter. I didn't know this.
It's a side hustle.
It's a side hustle.
Yeah,
eh?
Just a passion project.
Yeah. Tell me more about it.
Just briefly, people write in, say, I married the wrong person, I'm in the wrong marriage, I'm in a wrong relationship, and I need your help to get out. And most of the time, it's people who can't afford to find lawyers, they can't afford to pay for legal services, and they don't really have the luxury of generating all this knowledge and finding other options. Or they've tried and they've been failed by different systems. They've gone to a law clinic, somebody, no, come back, we'll sort it out, and they never got helped. They've gone to legal aid, and legal aid says, no, come back, we're swamped, and so they end up losing hope, and their next best solution is I go to a TV show. Yes, much as it's for them, it's about content, but for me, it's about finding a solution. And we end up finding a solution for them, They can't track and trace their spouse who they want to get divorced from. And apart from the not being able to track and trace the person, they don't really know what the legal process is. So they need some assistance to say, this is where you start, this is where you go, this is why you start here, this is why you go there, So they kind of get assistance that they wouldn't otherwise get from a lawyer. But there's also a limit to what we can do for them, because we need both of them to come onto the show, reveal their deepest, darkest secrets. So, then there's a conflict if you end up wanting to represent either one of them. So, but generally we try to find them a solution to say you're in the wrong marriage. Why?
Yes.
And what can we help you with? And half the time we help them with finding the person they're married to, getting the message across that I want a divorce, and starting the process. And some of them even I get to a point where they sign settlement agreements, and they get critical information, service addresses for the summons and so forth. So they do get quite a lot. And they then continue and finalize their divorces, as it were.
Do you find that it dovetails nicely with your practice?
Look, I think that's primarily why they approached me for that particular thing. Because I used to do a lot of cameo appearances on a lifestyle TV show aimed at teenagers and young adults. And the family practice is what appealed to them in terms of how you engage with these people in a vulnerable position and so forth. And also the family practice aspect in terms of how we find people, substituted service. So you understand the challenges of finding people, getting them served despite their best efforts to try and hide. So they lean on that experience for the production. And it works for us because, it's a nice little passion project on the side. It does bring in a bit of income, but it's also marketing and advertising for the firm and the brand,
So it sounds to me like family law is a huge part of what you do. Is that correct?
There's certain things that happen in life, and when you look back at them and you realize you can't even say whether you took a decision to go into family law or family law found you.
Yes.
I don't know what it is.
Yes.
But
you didn't set out to be a family lawyer.
No. And I think I actually know at the exact point I entered into family law.
Yeah.
I was doing a contract for a CEO of some entity, and
some corporate stuff.
And yes, and the CEO just had a small minor personal problem. She was getting married to somebody, and they couldn't start with the lobola process because that person hadn't yet divorced the spouse that he had left in 1996.
Yes.
So she just needed to sort out just that small personal problem. And I had to find templates for divorce summons. I had to find out what is the family advocate, how does the sheriff serve on this type of thing where the parties happy to do it. Is it necessary even to serve when parties are happy to do a settlement? And, just do a quick introduction into this family law business as a personal favor for this client.
Serendipity. And voila, now you are the biggest shot of...
And it mushroomed
of them all in town.
And while I was doing that matter, I go to court and I bump into someone crying at court. And why are you crying, ma'am? No, I've been doing this maintenance matter. I don't know what to do. And okay, let's see. And maintenance evolves into a children's court application, evolves into now you're doing divorces full on. And half the time, I find clients when I'm going to court to deal with a matter, as I'm leaving, it's someone saying, sorry, can I ask a question? Yes. And you end up doing those matters pro bono because they're there at court, they don't have the money, they don't have... And so I've decided it's we're not going to wait for the LPC to say, here's your pro bono case. I think they've given us 2 in a space of a year.
Yes.
So those become your bulk of your pro bono matters, and you take them and they become teaching exercises. One of them has yielded an agent application that I got the juniors in the office to do the drafting and the service and everything, So it ends up being a thing that consumes you, because all of these clients, all of them, refer everyone and their cousin and their cousin's dog to you, and it spirals and it spirals, and the next thing you know, 70-80% of my files are family matters.
Yeah. But now you're talking divorces. I want us to go all the way back. There's a saying, they say love is blind, but divorce is an eye-opener. So let's go all the way back to marriages, right? In our context, you have a lot of people like you and me who get married effectively twice. They start with what they call a traditional wedding, and then much later on they do what they call a white wedding. I don't know what they call it, a white wedding, because it's somebody's traditional wedding. But anyhow, so you have, as I said, traditional wedding and a white wedding. At what stage do we say that such a person is married?
You're asking me a very uncomfortable question, because it wants me to either respond technically as a lawyer or to respond within context of being a black person.
You can wear as many hats as you like.
No, I'll start with the second one.
Yes.
There is this misconception by a lot of people that a customary marriage is lesser than a civil marriage or a white wedding, as it were, because traditionally they go and do a white dress and suits, and there's an altar, and there's, and they would see that as the actual wedding.
Yes.
And they would see everything else as preparation.
Yes, as a build up to the wedding.
Build up to the wedding. But that is not always the case. You would have a lot of people saying, why must I waste money on a white wedding? We've paid lobola, we are happy, let's just continue. And then at some point, the spouse with the money says, no, actually, we were never married, we never finished off lobola.
Yes.
We never had a welcoming of the bride to the family, because that's a significant portion of our tradition and culture.
Yes.
And we never did a handover ceremony. We're Zulus, we never did a members or mabo. So there's always all of these nuances about what particular culture, tradition that you're coming from, and to what extent do you determine based on each one that marriage happens here.
Yes.
The misconception by a lot of people is that you are not married when they come and do the lobola. You are married when they come and finish the lobola and they go and do a handover ceremony. The High Court dealt with that issue. Joburg High Court, in a Sengadi versus Tambo judgment, dealt with that matter.
Tambo is WHP.
Yes. And there were many judgments before that, but that's the seminal one that kind of provided great clarity to say, look.
In fact, the judgment was penned by none other than, who's the judge who's doing the Senzo Meyiwa case now?
Ratamokhotle.
Yes.
Justice Ratamokhotle.
Yes.
The approach by the court was this. Law is not a concrete cube that doesn't evolve.
It's dynamic.
It's dynamic. It lives with society as it lives. It migrates and morphs with what society is morphing. The reality is this. You and your wife can decide that, no, you know what? We want to spend our money on a honeymoon. We want to spend our money on renovating our house. We don't see the need to do a white wedding or a 2-stage ceremony. Culturally or traditionally, in the past, it was you go there, you pay lobola, then they deliver the bride.
Yes.
That's why they would be on a Saturday and a Sunday. But no one still does that anymore. And you were marrying somebody who was 2 streets down the road from you. You are now from Limpopo. Your bride is from Eastern Cape. How are you going to do a Saturday in Limpopo, Sunday in Eastern Cape?
So are you speaking to the handover process?
Right. That handover process gets ignored in a lot of instances because it's impractical. It's too costly an exercise for a ceremonial thing, you know. And the court dealt with it by looking at it and saying, look, we look at each case on its own merits, but generally, couples these days do not embrace the full ambit of a specific cultural practice. In any event, when you go to any one culture, there is no authoritative position on what this Pedi culture is. Come to my family. There are 7 different people who have 7 different views as to what is the cultural practice. Now look at what we had adopted. And if we had decided to waive the requirement of the handover and so forth, are we then not married? It becomes an argument of convenience for me to say to my wife, no, you are not my wife. They didn't do a handover. But at the time when we were getting married, we chose to forgo that aspect because it was an impractical and it was an unnecessary thing as far as we were concerned. So it's generally, once you have entered into a marriage in terms of customary law, you go, you introduce yourself, Thato Mahapa, I want to marry your daughter. You want to marry our daughter, it will cost you 15 cows and each cow is 3,000.
Yes.
Oh, that's 45,000. Okay, sharp. We have negotiated and entered into the marriage. That's it. The rest is ceremonial things, sort of like to perfect it, but they're not mission critical.
So as long as there's a meeting, as long as there's a meeting of the minds between the two families,
yes,
then we're done. It's a marriage.
Then we're done. You're married. And the Customary Recognition of Customary Marriages Act says, do you have an antenuptial contract? No. Then you're married in community of property.
Does it have to be in writing?
What?
The agreement between the parties or the families?
There is no requirement in the Act. Section 3 of the Act says you have 2 consenting adults who want to get married, who have negotiated and entered into a marriage in accordance with customs. They're married.
I see.
It says nothing about there being a requirement for a lobola letter. It says nothing about there being a handover. No.
And you say the default position is that it's a marriage in community of property.
The Act says unless you have an antenuptial contract, you are married in community of property.
So in other words, if you want a marriage out of community of property, a customary marriage out of community of property, you've got to have an antenuptial contract drafted beforehand.
You go to the lobola negotiation.
Failing which?
You're married.
You're married in community of property.
Yes.
What does it mean? What's a marriage in community of property?
Shamina, shamina. Joint estate. If I go and borrow 50 rand from somewhere, you have borrowed 50 rand as my spouse. If I get a windfall and I win a competition and 100,000 there, you have won 100,000. There is no me, there is no you, there is us. It's very qualified instances of a me and a you, but I think for the purpose of this conversation, yes, there is no you, there is no me. There is a unit that we are components of, and that unit is what we call the joint estate. The joint estate owns all the assets. The joint estate is responsible for all the liabilities. The fact that I owned 6 houses before we got married and you had 1 mkuku and now, no, the joint estate owns 6 houses and a mkuku.
So what happens in the event that I am reckless with finances? I'm married to somebody else, but I am reckless in finances and I have to be sequestrated. What happens?
There is no you. We are being sequestrated. We are being sequestrated. We are responsible for the debt because it is the joint estate that is liable for the debt. And I've seen an instance where someone was being sued and their defense was non-joinder because you didn't join the spouse.
Yes.
You know, and there was a valid defense. They had to do a joint application to bring the other spouse in. You know, and I've seen a defense to a suit on a credit agreement that you gave me credit. I declared I'm married in community of property.
But you didn't follow
and you
it
didn't
up.
establish that I had the consent of the spouse, and you didn't seek the consent of the spouse. So that constituted reckless lending, because you have to treat it as a joint estate. I mean, if we're looking at places like the deeds office, it's one place where they make you feel that you are a joint estate,
Yes.
because you can't do anything without the consent of your spouse as long as you're married in community of property. There's very few things that you can do without the consent of the spouse, but generally, you want to you buy a house, the wife must sign. Doesn't matter that you
Or
are
the
paying,
husband.
it doesn't matter that you are paying 100% of that debt, and no. Even the bank will not give you a loan to buy that house. Your wife must still, even if she's going to contribute zero, or even if I'm going to contribute zero to that bond, as long as I'm married in community of property and my wife is buying the house, we are buying the house. And when she defaults, we have defaulted. Simple as that.
Before we go to the other types of marriages, we are, of course, talking within the context of Africa, where polygamy is still a big thing. What happens in an instance where a man, say, marries 3 or 4 women?
So, there it's not so cut and dry. Primarily because you have the Recognition of Customary Marriages Act, and Section 76 says you want to enter into a polygamous marriage, you must apply to court to register, to get leave to enter into a contract, that first you dissolve the joint estate, and then you get into a contract to manage or govern the proprietary consequences of this existing marriage as well as the next marriage.
You know, this discussion is very important, because coming from the villages, you'd remember that there was a time where our men would work in the cities. They get married in the villages, or they don't even consummate the marriage in the villages. So they marry. This is before the Recognition of Customary Marriages Act. So they so-called get married in the villages, come all the way to the cities and enter into a civil marriage. Problem arises when the poor guy passes away, because the civil marriage would be the one on paper. Do you still have such instances, or do you find that the Recognition of Customary Marriages Act has gone a long way in sort of obviating that problem?
No. I'll start with the last one. The Recognition of Customary Marriages Act hasn't really dealt with it. It's there on paper and says this is what must happen. Is that what people do? Not always. What you end up having is this. There are still judgments coming out in the courts, present moment, where someone comes and says, no, that person can't be appointed an executor. I'm married to the late person. They say, no, I'm married to the late person. Here's my marriage certificate. So says, no, I got married. Here's a letter from the chief.
In such an instance, do you find that the marriage, is it law that the marriage certificate would take precedence?
No. A marriage certificate is but one way of proving the existence of a marriage. It is not a way of proving that this is the most superior marriage ever. So there was an instance, there's a case, I forget the name. There's a lady who lived in Flora Park in Polokwane.
Yes.
And she owned the house with the deceased, and she had a marriage certificate. And then some other lady popped up saying, no, I was married to him first. And I think the court in that case set aside the second marriage but also did a distribution of the assets to which she was entitled to. There's a case, Mailani versus Ngwanyama, KZN, taxi driver, wife here in Johannesburg. And in that, what set that case as apart is that the second wife knew about the existence of the first wife. There's a constitutional court case, I forget the name now, but the court delved into customary polygamous marriages within the Tsonga or Shangan culture. And there are several criticisms to that judgment because it looked at certain things for the first time as the apex court, and probably would have been better to send it back, but that's just one view. But and it made a decision which there are different views from different scholars about what impact it has. Does it invalidate if a man enters into a second customary marriage without having obtained leave of the court to dissolve the joint estate in the first marriage and to authorize a contract to regulate the proprietary aspects? Does it then mean that the second marriage is invalid? No. There are judgments that say, no, it's not invalid. Right? At best, it's a marriage out of community or property. But now, that also is untenable because it pits the two spouses subject to different proprietary regimes. There was another judgment, I think it was Malani versus Ngonyama, where they declared the second marriage invalid. So one still has to do a thorough analysis of all the cases to say what actually is the clear position on this. I had the benefit of being involved in a debate with candidates who were writing the conveyancing exams now in September.
Yes.
And I can tell you this
Are those the exams where you insist that they must not be written by hand?
We'll get there one day. But we had an entire debate, and there were as many views as there were attendees.
But what does it mean? Does it mean that the law is in a state of flux? Do we have settled law when it comes to customary marriages, or our notion of customary marriages? Is the law settled?
I think the law is not yet settled in the sense that it still could do with a bit of maturity. What happens in instances where a man enters into a polygamous marriage and does not obtain leave of the court for that contract and does not dissolve the joint estate? There needs to be some form of consequences to deal with that aspect. In terms of the Act, it's silent on that. In terms of the different judgments that exist, in some instances, the second marriage has been declared invalid. In some instances, they haven't been declared invalid. So I think that is one specific area where you still need a lot of research and a lot of development into that law. But also it becomes difficult to come with a very clear position on that aspect because it involves pitting two systems against each other. Yes. You have a common law, or you have statute, you have customary law, and you have to find a balance between the different systems and the approaches to come to a concrete position and say, this is what should happen. People think that, it's modern day prevalence of customary marriages is not there anymore. But you'd be surprised in practice how many times you come across customary marriages that are polygamous marriages and the participants there are 30, 40, 50 years old, and the marriages themselves are 3, 4, 5, 6, 7, 10 years old. It's still a practice that it's happening. In some instances, people just prefer to do it informally because to go and get a Section 7(6) order and a contract is just going to be tedious, so we're just going to do it this way. Because the law doesn't say unequivocally, if you go and do this, you don't comply here, these are the consequences. And much as with customary marriages, that's why you still have a a lot of people thinking that if we've negotiated lobola, we can still do an antenuptial contract afterwards. There's a case 2021 September.
Before you get to the case, antenuptial contract, because I need us to sort of break down the concept.
No, before we get to antenuptial contracts,
Yes,
the 2021 September judgment clarified the aspect that if you want to change the proprietary consequences of your marriage, before you get married, you have to do an antenuptial contract before you do the lobola.
That's where we're converging. Because antenuptial contract, I need you to break it down.
What is
it?
Right.
We are influenced by a lot of American media. They speak of a prenup. In our context, we're talking of an antenuptial contract, an ANC. What is it?
It's a prenuptial contract. Prior to the marriage, antenuptial prior to the nuptials. Before you get married, you enter into a contract. And the contract says...
What does it entail?
Our marriage. The contract says, who is entering into the contract? This person and this person are entering into a contract. Why? They intend to get married. And they wish for their marriage to be out of community of property. The reason why they need to do that is because in terms of the Matrimonial Property Act, it says, if you get married in South Africa without an antenuptial contract, by default, you are married in community of property. There are other jurisdictions where the default position is different. For South African context, if you get married today, you are married by default in community of property unless you've entered into an antenuptial contract.
Now, when you were talking about marriages in community of property, you were talking about instances where the consent of the other spouse has to be sought. In marriages out of community of property, where you've entered into an ANC, do you still need to obtain the consent of the other spouse?
Well, I mean, if you're afraid of your wife, like I am mine, I still need to get a consent either way. But there is no creation of a joint estate. Each person retains their own estate. They are responsible for their debts. They are liable for whatever arrangements they enter into, and they
could be sequestrated to the exclusion of the other party.
That is a very technical issue when it comes to Section 21 of the Insolvency Act. The general common misconception amongst attorneys is to advise clients to get into antenuptial contracts because you've retained a separate estate and therefore you can't be sequestrated for the liability of the one. The liquidator has powers in terms of Section 21 of the Insolvency Act to take control of the estate of the solvent spouse.
Is that a general position or...
That is a legal position.
I see. Then you have another type of matrimonial proprietary regime where a person could be married out of community of property, out and out.
Out of community of property has two options. Out of community of property with accrual or without accrual. What does it mean? Where we are married out of community of property without accrual is what is colloquially referred to as out and out. There's no joint estate. What I owned before remains what I owned before. What I was liable for before remains mine. What I make in the future, what I'm liable for in the future, doesn't matter.
Let's speak with reference to sequestration in that instance. What would happen? So say one estate gets sequestrated. Does the liquidator still have the powers to go after the other?
The liquidator has the power to go after the other,
irrespective of the matrimonial proprietary
regime. And it is
so there's no running away from the liquidator.
It is then incumbent upon the liquidator to then take an election at a certain point to release the estate of the solvent spouse. You know, think of it practically this way. I'm getting sequestrated and I put all my assets in my wife's name. I move all the cash into her name. Liquidator comes to my estate and finds nothing. Right? The liquidator must have the power to take over my wife's estate so that she can justify which of her assets she wants to be taken out of liquidation and on what basis, and how she got any of those assets, how she funded them, how she acquired them, what title, ownership title she has to any of those assets outside of my estate. Right? So it's a question of practicality from a liquidation perspective. You know, that the liquidator must be able to take over that estate and determine whether genuinely there is a separation of estates and there is this, and to determine at what point can the liquidator release that estate of the solvent spouse. Imagine we're married out of community of property. My wife is a stay-at-home wife and I've registered everything in her name. I'm effectively doing this to defraud my creditors.
Evading your creditors.
Yes. Because all of those assets and the liabilities stay here, the assets are there. And then the creditors have no recourse. So if the liquidator was to take over that estate, they'd be able to show that, no, actually these assets belong to this estate and not that estate. So irrespective of a matrimonial regime, the liquidator can still take over the estate of the solvent spouse.
Yeah. We should have started with this from the onset. This is not a substitute for proper legal advice. You still require to consult with an attorney.
Yes.
Because each case depends on its merits.
And the other part is that there might also be attorneys that see things differently from how you
that's an interesting thing about law, wouldn't you say?
Yes. In fact, it's the one thing I like the most, and it's the one thing I hate the most. You know, but a person is always better off going to consult, because we are talking general positions. We're not talking specifics, and the specific things that, you know, any advice would have to consider those, you know, specific issues. So yes.
Having said that, would you want to sort of tell me, of all the regimes that you've spoken about, do you have one that you prefer?
No. I prefer that my clients get into a matrimonial property regime that works for them.
Based on their personal circumstances.
Based on their circumstances. You know, there is no one that's better than the other. It's always what works for you. Why do you want to get married? It's a legal decision and it is an emotional decision. We're not talking about the emotional aspects of it. We're talking about the legal aspects of it. A marriage is a contract. It is a legal contract. It is a governed system. It has consequences. Do you know and understand the consequences that come with being married? You know, even if you decide to end up getting married in community of property, still go and consult. Find out what options do you have and why would you want to take a specific option as opposed to another.
It wasn't always the case that people would consult before they get married, but I'm seeing a lot of people coming through now.
And I'm happy that I'm seeing younger people consulting before they, as soon as, you know, somebody says, I think we want to get married, they immediately start to have a conversation. And I'm happier that it's happening. But I'm also still seeing a lot of, no, we paid lobola last month, we're getting ready to go sign at Home Affairs, we want to do an antenuptial contract. I'm like, it's not, I can't. You know, there are attorneys that will register them for you. And you will discover years later that you have a problem in good conscience and with my ethical
so it's a no
responsibility. I can't. And, you know, they still go somewhere else. And when they don't come back, and half the time, they always come back, say, okay, what else can we do now? There's a postnuptial contract. You can change your matrimonial property system after you've been married.
What does that entail? Where do you go?
It is an application in terms of Section 21 of the Matrimonial Property Act, and you apply to the court for leave to change the matrimonial system, to enter into a postnuptial contract, and for the court to grant you an order effectively converting your matrimonial property system from one system to another. Generally, it's people moving from out of community property to from in community property to out of community property. And there's a bit of an involved process that requires you to notify all your creditors, to, in some instances, to obtain their consent, as it were. Not that it's consent, but more that you enter into an agreement or an arrangement with them and that they're happy with. And once you've done that process, you've done the antenuptial contract, the court then approves the postnuptial contract, and the court approves that, yes, you have not prejudiced the interests of your creditors, you've notified all of them, they've participated in their process, you've gotten to the arrangements, they're happy, there is a postnuptial contract, the court has considered the terms, the court is happy, then it grants an order for the Register of Deeds to then register that contract. And then your marriage is effectively out of community of property.
As you say, it's quite an involved process. It's an application that you make to the High Court.
Yes. And it's an application that you make in 2 stages.
Costs. I hear that you guys are very expensive.
Costs. How long is a piece of string? It depends. It depends on, some instances. I mean, there's one I'm doing a consult on in the week, and they've literally just paid lobola 3 months ago, and they've realized the error, and they have agreed to do a postnuptial contract. They don't really have a lot of creditors, so there's going to be less people to notify and interact with, and so the cost will be slightly on the lower end. There's one where this couple had been married for about 25 years before they converted, and they had a whole host of creditors that needed to be notified, and negotiation for the reconstruction of credit agreements had to be done with those entities so that they can be satisfied that they're not losing the kind of protection that they had where they were contracted with the joint estate, because now it's joint and several liability and so forth. So the costs really are dependent, and I'd be loath to mention a number. It is dependent on each particular set of facts and what is the level of administration involved and how much time and effort you need to put into it.
What would you say to the notion that it would, in such a scenario, it would probably be much easier just to get divorced?
Well,
and probably remarry in the future.
I've refused to do that before for a couple that said we want to get divorced and then get remarried so we can change our matrimonial property system, but also we don't have money. We want to be able to access the pension funds because this is the one avenue where we can access pension funds in the divorce process. I wouldn't advise get divorced to remarry. When you are getting a divorce, you effectively say to the court, I am married to this person. I want a divorce on the following grounds. There is no ground that allows you to divorce and remarry because you can change your matrimonial property system. So whatever is contained in your summons, it's a lie. You're committing perjury. Right now, I have a case where this couple was married in 1994. 1998, they divorced and remarried. Mm-hmm. At no point were they living separately. At no point was there no love and affection. At no point was there an irretrievable breakdown of the marriage relationship.
So the divorce was a sham, you say?
Indeed. It was a sham. But now, 19 years later, the wife wants a divorce, and according to the husband, no, we are married out of community of property with no accrual. You don't have a claim to my assets. And she says, no, but I thought we were married in community of property. She said, but you signed an antenuptial contract. Now the debate is, was that divorce decree actually valid? If both parties had misled the court, can the court now set aside that divorce decree and say, no. We set aside that divorce decree, and we set aside the antenuptial contract that you entered into, and effectively we are reinstating your marriage in community of property.
Even putting aside the divorce decree in your example, it sounds to me that she didn't have a full appreciation of what she was doing when she entered into the ANC.
Well, that's her argument, that we went to his attorney, and his attorney advised us to do it this way, and that there would
So she
be
was
no
duped
change.
in a sense.
That's her argument. And the reality is this: in marriages, who has the greater advantage?
Tell me.
The one with the money. And who often has the money? Historically, it's always been it's been a male-dominated economy. It's always been the men who have the money, who are able to influence decisions and positions and so forth. And unfortunately, in a lot of instances, it's the wife who finds herself at the receiving end of a team of 5 attorneys and 2 advocates, and all of them fighting a divorce against this one person who doesn't even have the assets to go and challenge any of this. So at the end of the day, it's really a perpetuation of some form of...
Are you suggesting that the lawmaker has some work to do in order to sort of equalize the playing fields?
No. The law has already done that. I mean, you have 2 things. You have Rule 43 in terms of the Uniform Rules of Court that says during a divorce process, irrespective of the regime, a spouse can come and make a claim for maintenance in the interim, pending the conclusion of the divorce, whether spousal maintenance or for the children, and they can make a claim for contribution towards the cost of litigation. And the courts have generally dealt with those applications. If you are able to show the basis upon which you're making the claim, you can have a cost contribution. I've had a matter where my client was ordered to pay 700,000 towards the cost. And he paid the 700,000 towards the cost of the spouse who had been a housewife for 19, 20 years. So there's that relief that exists during the divorce process itself. And in terms of the finalization of the divorce process, you also have Section 7.3 of the Divorce Act. The court can make a redistribution order. So when you're married in community of property, that's easy.
Yes.
We divide the estate, settle all the liabilities, divide whatever is the residue of the estate, or you can enter into an agreement to divide them amongst yourself, whichever way works. If you can't agree, we go to court. The court either appoints a receiver and liquidator, or the court hears the matter, you lead your evidence, court gives you an order, done. Out of community of property, with or without accrual. Where there's accrual, the court says, okay, you started out with 50 rand. I started out with 2,000. My estate has increased by 100 rand. Yours is increased by 1 million. Let's take the growth of your estate. That is what we call your accrual. We take my accrual. We take the lesser one, divide it from the bigger one. Mm-hmm. Whatever is left over, the one with the higher must pay half to the other one. Simple. Where there's no accrual, what happens? I've been a house husband for 20 years. I drive the kids to school, take them to swimming, take the dog for a run, keep the car serviced, and my wife is the one making all the money. And now we want to get a divorce 20 years later. and she simply says, no, you don't have a claim. I'm married out of community of property with no accrual. What relief do I have? I can make an application in terms of Section 7.3 for a redistribution order to say, in the interest of justice and parity, I contributed to the growth of my wife's estate. My contribution is not limited to financial or monetary contributions. I allowed them the space to flourish, and I am entitled to a redistribution of some of the assets. And that is relief that the court can grant on application beyond or over and above what an antenuptial contract provides. My estate could have increased by 10,000 in the time that we're married, and yours has increased by 20 million. Why can't I claim for a redistribution over and above the distribution of accrual? So there's other relief that the court can grant, but one has to apply for it. And one has to know what sort of relief is available. Just because you're married out of community of property without accrual doesn't mean there is no form of relief that the court can enter into. There is relief that is available.
Section 7.3 doesn't enjoy as much high spotlight as the others. It's almost like, and I want you to speak to it now, it's almost like forfeiture of benefits. What is forfeiture of benefits when we're talking marriages?
Forfeiture of benefits is an area of law that is getting a lot of judgments out now because everyone has become alive to forfeiture of benefits.
It's getting some kind of traction.
Yes. It's getting some kind of abuse also. We're married in community of property. During our marriage, you gambled, you didn't contribute to the household, and I took care of the house and blah, blah, blah. It would be unfair if you were to be entitled to the patrimonial benefits of a marriage in community of property. In simple terms, I've increased my pension, I've built a house, I've made savings. It was all my effort, and I was just carrying you like a dead weight. And now you want to claim half of this estate. Why? You must be ordered to forfeit. In law, you have a claim to half. You must be ordered to forfeit this half. Or we're married with accrual. And this accrual, I spent the time and energy and effort to increase my estate, and you were just chilling there. You must not claim this, must not be entitled to exercise this accrual claim to this estate of mine. If you do, you will unduly benefit and I will be prejudiced. Lockdown was a very interesting time for marriages.
Mm-hmm. Big test.
Some people were forced to stay with their spouses for more than 24 hours that they had never experienced before, in a long time. There are marriages from 2019, 2020, 2021 that they're coming and saying, I want a divorce and I want forfeiture. The marriage has been short in duration, and this person hasn't contributed. I already had a significant estate by the time I got into the marriage, and they shouldn't get a claim. So there's relief that one can claim in terms of Section 9 of the Divorce Act to say, I want the person to forfeit the claim they had to the accrual or forfeit their claim to the joint estate to the extent that they're entitled to claim against certain assets of mine or from the joint estate in totality. You can make that prayer for forfeiture of a specific benefit or of all the benefits. So there's a lot of cases coming out now and a lot of divorces harping on about the duration of the marriage. And people make the mistake of saying, yeah, you were married for 2 years, therefore it wasn't a long duration. That is not, it's not the determinative element. you know.
And besides, there's no hard and fast rule when it comes to
Forfeiture.
that. Yes.
Yes. So it's a blend of all the circumstances. You know, we look at all the elements and then the court makes an order that is just and equitable based on the circumstances of each case.
You do say, though, that it's prone to abuse.
A lot of instances, it's being used as a stick. It's a threat in pleadings to say, if you dare go to trial, you're going to face this forfeiture. So just take this unfair settlement, and I will be generous enough to give you an extra 20 cents and an extra 3 rand here, and you can keep the light that I bought you on honeymoon last year. You know, it's been used as a bargaining strategy or as a threat in pleadings to sort of coerce people into accepting less than favorable settlements, so to speak. You know, and I don't know if that is an ethical thing to do. I don't know if, you know, one strays beyond the limits of what we can do in an effort to best protect our clients' interests. But I'm not one who's a fan of abuse of the forfeiture provision. Simply because it's there doesn't mean you must always throw it out. You know, there's instances where I've seen it being claimed. Parties were married in 2015. They lived together for 4 years. Marriage disintegrated. Wife bought a house when she was allegedly kicked out of the house by the husband. Pays for school fees for the child and so forth. And now they want to claim forfeiture because the marriage itself was actually only 2016 to 2017 when we were living together. But for all the 4 years, they were living as husband and wife, and the only times where they were not living together is because of a work assignment. One was assigned there, one was assigned there, and for as long as they were not at work, they were here. And I'm like, but now it's just an abuse of this,
But fortunately, the courts do look into that. So they do like a factual inquiry, and they would investigate the circumstances relating to such a case.
To such a claim. Yes, and luckily you get the courts are not the courts have not always been inclined to just grant forfeiture. Now you're getting increasing instances where forfeiture is being granted, and I don't know if that's a reflection of a better understanding of the section and a better packaging of the arguments to convince a court, or it's a reflection of the courts being less strict about forfeiture and being more, wanting to reprimand the conduct of the parties in the matter. I'll have to look at the judgments there and see, but I'm seeing a lot more judgments dealing with forfeiture than before. And I don't know if that's necessarily a good or bad thing, but it's happening.
At the very beginning, you spoke about substituted service. Right? What is it?
So, in simpler terms, the rules of court require that in certain instances, when there is a summons issued or an application, as long as there's a new matter, a person who is the subject or the recipient of whatever order you seek there must be served.
Personally.
Served by the sheriff. Right? There are exceptions to that requirement, but generally, that's the requirement. In divorce proceedings, when I commence a divorce, I must serve the spouse who is being divorced.
The spouse is called a defendant.
The defendant.
So the defendant must receive the summons.
The summons personally.
Yes.
In some instances, you don't know where they are. In some instances, you know where they are, but it's going to be very difficult for you to serve them. So you then apply to court for authorization to serve in a manner other than personal service that is set out. In the High Court, they call it a dictal citation, and a dictal citation comes in a number of ways. You can substituted service that I've once had authorization for was the person said, I work for the South African government in Switzerland. I've appointed an attorney in Pretoria. I have given them the power to accept service on my behalf. They deposed to an affidavit, and that affidavit is what went to court when we were doing an application for the court to authorize service of the summons in a divorce matter on a person other than the defendant, being the defendant's attorney. And given that there was an affidavit by that person, the court agreed to serve that person. In another instance, we traced the defendant to Texas in the US. And the question was, how do we serve him? You can either...
Because you can't have a sheriff here hopping on a plane
to go and serve there. So you can either get the court to approve a specific method of service where you're taking the documents, who is the equivalent of the sheriff there, and how are they going to serve, and where they're going to serve, and what documentary proof do you then receive that they've served, and how does it come back, and then, Alternatively, we simply said to the court, look, this person, we know where they are. We speak to them regularly via email. In fact, here's an email they responded to yesterday. And the court authorized substituted service via email and WhatsApp. And we sent them a WhatsApp, and they received the message and they read it. And the delivery report on the WhatsApp was one part of the proof of service, because it says it was delivered and it was read. And then the email had a delivery report, and they sent a read receipt as well. So that constituted sufficient knowledge of the matter.
Yeah.
So substituted service is you going to court and saying, I need to serve a process, and I need the court to authorize me to serve in a manner other than what is the default required in terms of the rules. And here is how I would like to serve for the following reasons. And once the court gives you that, then you're going to serve it that way.
And the list that you gave is not exhaustive.
It's not exhaustive, yes. There are other ways.
There are instances
you can
where
publish in the government gazette, you can publish in a local newspaper, you can get authorization to serve on the person's employer if you know where they're employed. For someone, for example, I had a matter where this gentleman worked for an alcohol distribution company, and he was a field agent. And his employer, his own employer, said, listen, even when I want to, I can't give you a schedule that confirms where he will be next week. His schedule is decided on Friday for the next week. And even then, the schedule is subject to change. So I can never give you a pinpoint location. The only way you can locate him is if you do triangulation on a cell phone. And to get an order to do triangulation on a cell phone, good luck.
Jeez.
It's a different story. So they were not trying to be difficult, but they were saying it's very difficult. If he's trying to hide, he's trying to hide. And I can't even say he's at the office at this time, blah, blah, blah. So then, but we said, does he come to the office? He said, no, he has to come to the office every day. Whether in the morning, afternoon, whatever, he has to come to the office once a day. So the court gave us an order authorizing us to serve on the employer. And it became the employer's responsibility to make sure that he received it. But we emailed it to him as well. And it was emailed by the sheriff. Because then the sheriff is the one that gives the return of service saying, I have served the process as follows, and here's the proof of service. And the matter was concluded with the gentleman being served through the employer and via email by the sheriff, because it was a matter that had an effect on status, so he had to be served in person.
Now, this is the Professionals Network podcast. You are a big shot, family law attorney. There's somebody who would be watching you, who wants to be a family law attorney. What characteristics should they have? What should they have?
They have to be crazy.
Crazy?
Yes. You have to be crazy to believe that there is always a solution. Because when you're a family lawyer, it's not possible for you to just simply say, this one can't be solved. You have to believe that there is always a solution. No matter how much the parties involved are angry and fighting, no matter how toxic the environment is, you have to believe there's always a solution. There are many other aspects. I mean, I was doing a commercial matter on Thursday, business rescue proceedings, and all sorts of criticism about the Companies Act and what it does for business rescue and, insolvency. And so we live in interesting times where the Constitution has come in and everything else is trying to find where it fits in relation to the Constitution. And there's all sorts of things being declared unconstitutional. There was a South African Law Reform Commission was doing a study into the required revision of the Maintenance Act and the maintenance, the general maintenance framework, starting with the Act, with the courts and the system. There's a investigation into the Children's Act and the many contradictions it contains. That the High Court can grant an order to terminate. The Magistrate Court can grant an order to terminate parental rights, but it can't give you an order in terms of Section 18.5 for you to independently exercise the right to consent to a child leaving the country. You have to go to the High Court. But it can just terminate your rights, and then effectively you have that. It's nonsensical. Yes. That, the court can do this, but it can't do the smaller thing. There's many other contradictions in there, and there's an attempt to reimagine, as it were, the Children's Act. So there's a lot of things that are happening in many different areas of the law based on the simple fact that our Constitution is not yet fully developed, or the systems underpinning the Constitution are not yet fully developed to appreciate and understand the impact of the Constitution. So it's very interesting times for one to become a lawyer under those circumstances, because there will never be a boring day. I've never had a day that was similar to any other day. That's the best part. There are other professions where what you do the same thing Monday, Tuesday, Wednesday, Thursday, Friday, and then next week is the same old. Yeah. And then there's a new client, and it seems like it's different, but it's the same. I guess you can say it's a divorce. Yeah. But every divorce
but
is
nothing is
different.
Predictable here.
Every you're negotiating an antenuptial contract. Every single one is different.
Different nuances, different parties.
And there's always going to be room. There's always going to be room for new knowledge, new learning, new challenges, new areas. I would definitely say yes. Come and do law, but you must know why you want to come to law, what specific area do you want to go to, and why that specific area. But there is definitely a lot more, and that's worth coming into law for.
In conclusion, I'm saying conclusion because you and I can talk forever about our favorite subject.
Yeah.
You mentioned the Constitution. The Constitution is an overarching law in this country. Every law, every custom has to be consistent with the Constitution. When you're talking marriage, the traditional understanding has always been a contract between a man and a woman. Are we still there?
No. Civil Union Act. They have a Civil Union Act that says civil union can be entered into by two persons who are over the age of 18, which can be solemnized in a marriage or through a civil partnership, to the exclusion of all others while it lasts. So you can't have a polygamous civil union. You can register a marriage, and if the marriage officer doesn't want to, you can't compel them. You can go to another marriage officer, but you can go and register a marriage between two parties. Or they can enter into a civil partnership with or without community of property, if they don't specify that civil partnership is in community of property, or that civil marriage is in community of property. So no, we're past the era where it was husband and wife. Yes, we still generally speak to it as husband and wife, but we're not there anymore.
There you have it, the Professionals Network podcast with my big friend, Thato Mahapa, an attorney at Mahapa Incorporated. Thanks for coming.